Just hours after this August 11th, 2022 telephone call, Attorney General Merrick Garland took the unusual step of holding a press conference to deliver remarks regarding the search of Mar-a-Lago and the government's motion to unseal the search warrant and receipt for property. Mr. Garland made no mention of President Trump's clear and unequivocal message to him. In fact, the government made no response at all to President Trump's invitation to help reduce public consternation with the government after the raid. Instead, Mr. Garland stated in pertinent part, just now, the Justice Department has filed a motion in the Southern District of Florida to unseal the search warrant and property receipt relating to a court-approved search that the government conducted earlier this week. The search was of the premises located in Florida belonging to the former president. The department did not make any public statements on the day of the search. The former president publicly confirmed the search that evening, as is his right. Copies of both the warrant and the FBI property receipt were provided on the day of the search to the former president's counsel, who was on site during the search. The search warrant was authorized by a federal court upon the required finding of probable cause. First, I personally approved the decision to seek a search warrant in this matter. Second, the department does not take such a decision lightly. Where possible, it is standard practice to seek less intrusive means as an alternative to search and to narrowly scope any search that is undertaken. This public statement is deeply troubling, given that President Donald J. Trump is the clear frontrunner in the 2024 Republican presidential primary and in the 2024 general election, should he decide to run. The statement clearly suggests that the decision to raid Mar-a-Lago a mere 90 days before the 2022 midterm elections involved political calculations aimed at diminishing the leading voice in the Republican Party, President Trump. All facts laid out herein show there was complete cooperation between President Trump, his team, and the appropriate agencies. Mr. Garland's remarks stray from long-standing DOJ policy. The decision by Attorney General to conduct a hastily prepared press conference to announce his intention to release the search warrant and receipt for property was an ill-founded reaction to the public outcry that followed the raid on President Trump's home. 3. Argument. A. The extraordinarily unusual conduct of the DOJ raises fundamental Fourth Amendment concerns. The Fourth Amendment to the Constitution of the United States provides as follows: the right of people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Prior to any indictment and the availability of various grounds of suppression from evidence at trial, the mechanism that protects the rights of the individual from unreasonable searches and seizures in Federal Rule of Criminal Procedure 41G, the rule specifically contemplates protecting the rights of citizens who have been aggrieved by an unlawful search and seizure of property. Even as the government has dug in against transparency in the instant matter, fighting release of the affidavit and claiming redacted version would be worthless due to the need to hide the actual substance of the sworn statement. There are significant red flags that implicate President Trump's Fourth Amendment rights and cry out for judicial intervention by way of a special master monitoring and discovery assistant. The warrant is facially overbroad, permitting agents to seize boxes of documents merely because they are physically found together with boxes of other items purportedly within the scope of the warrant is clearly overbroad. As instructed by the Supreme Court and the 11th Circuit, the Fourth Amendment requires that those searches deemed necessary should be as limited as possible. United States versus Blake, 868, F3D 960, 973, 11th Circuit, 2017. The specific evil that limitation targets is not that the intrusion per se, but of a general exploratory rummaging in a person's belongings, was permitted during the colonial era by the general warrant, which the Fourth Amendment is specifically intended to preclude. It is familiar history that indiscriminate searches and seizures conducted under the authority of general warrants were the immediate evils that motivated the framing and adoption of the Fourth Amendment. Moreover, boxes of personal documents, photographs, and items such as clothing are by definition not contraband and thus may not be lawfully seized. In fact, the search warrant's broad scope was in violation of the Fourth Amendment's particularity requirement, and thus the warrant permitted a general search prohibited as unconstitutional since red-coated soldiers created the need for the requirement in the first place. Next heading, the government sought to improperly evade limitation on enforcing the President's Records Act. The investigation regarding President Trump's return of the 15 NARA boxes involved a NARA referral to the DOJ based on questions relating to documents falling within the Presidential Records Act. But the Presidential Records Act accords the president virtually complete control over his records during his term in office. Armstrong versus Bush, 924 F2D 282, 290, DC Circuit, 1991. There is no criminal enforcement mechanism or penalty in the Presidential Records Act. Did DOJ's National Security Division recognize that deficiency and then decide to recategorize this case as relating to national security materials, simply to manufacture a basis to seek a search warrant? Relatedly and importantly, did the National Security Division and the FBI mischaracterize the types of documents it sought to seize in an effort to avoid the lack of an enforcement mechanism in the Presidential Records Act? Next heading. The government's reckless pursuit of a search warrant implicates well-established bases for suppression under the Fourth Amendment. Under controlling Supreme Court precedent, a search warrant violates a person's Fourth Amendment rights and is invalid if the affiant either makes material misstatements or makes a material omission in the affidavit. Franks versus Delaware, 438 U.S. 154, 1978. Did the DOJ mischaracterize or omit from its affidavit The true extent of the president's cooperation, press reports by anonymous government sources raise this question. In addition, did the affiant to the warrant fairly disclose any pretextual or dual purpose at work in obtaining the warrant? For example, the receipt for property largely fails to identify seized documents with particularity, but it does refer to the seizure of an item labeled Executive Grant of Clemency regarding Roger Jason Stone, Jr. Aside from demonstrating that this was an unlawful general search, it also suggests the DOJ simply wanted the camel's nose under the tent so they could rummage for either politically helpful documents or support other efforts to thwart President Trump from running again, such as the January 6th investigation. Increasingly, in the government's response to motions to unseal the search warrant affidavit, the government claims public exposure of the affidavit would jeopardize the investigation and other high profile investigations. The phrasing suggests that DOJ has other interests at work than simply collecting documents with classification markings. Finally, the elements of national security statutes, such as those referenced by the search warrant, as well as the administrative process of classification and declassification, are complex matters. Did the affiant fully disclose the strictures of these statutes, as well as the president's overarching authority to declassify documents? Did the affiant disclose that there are public statements by those with knowledge indicating the documents sought in this search had been declassified? These are the types of material omissions that implicate Franks and could establish a clear violation of President Trump's Fourth Amendment rights. The government has long treated President Trump unfairly. The FBI and DOJ have demonstrated a willingness to treat President Trump differently than any other citizen. 2 years of noisy Russian collusion investigations led to a special counsel's finding of biased FBI agents and officials. Stories of FBI agents engaging in information laundering, where a fired informant continued to feed the FBI false information through a DOJ official to investigate the president, and even an FBI general counsel lawyer falsifying documents to support a Foreign Intelligence Surveillance Act warrants penetration into then candidate Trump's inner circle. An assistant director at the FBI was referred to prosecution for lying repeatedly about the Trump probe and text exchanges between the lead agent, Peter Sторrs, and his paramour, Lisa Page, reflect their complete disdain and bias against President Trump and his supporters, while they were entrusted with probing the farcical Russian collusion claims. Without further information from government, President Trump currently has no ability to assess whether any FBI agents involved in the Russian defamation matter are participating with NSD in the current situation. Historically, courts tend to give significant deference to law enforcement representatives who weigh in against non-disclosure of potentially sensitive materials because of investigative needs to or witness safety. But in light of recent FBI behavior, when President Trump is part of its aim, this court should feel obliged to demand candor and transparency. and not just trust us assertions from DOJ. The appointment of a special master with a fair-minded approach to providing defense counsel with information needed to support any Rule 41G filing is appropriate use of this court's authority on such sensitive matters. B. This court should appoint a special master to protect movement constitutional rights. Movement requests that this court appoint a special master pursuant to Rule 53A1B of the Federal Rules of Civil Procedure and this court's inherent equitable powers and authority. This step, which the government itself has requested in cases involving the seizure of privileged and/or potentially privileged materials, is needed to preserve the sanctity of executive communications and other privileged matters. Furthermore, movement requests that this court issue a protective order enjoining the United States from any further review of items seized until this court can rule on the present motion. See Federal Rule of Civil Procedure 26B 5 and C1 semicolon Southern District of Florida 26.1G. In addition, movement requests that this court direct the United States to prepare and provide a specific and detailed receipt for property. See Federal Rules of Criminal Procedure 41F. The receipt for property provided to movement on August 8, 2022 is so vague and lacking in specificity that the reader does not know what was seized from movement's home. Seized documents reflecting presidential communication with advisors are presumptively privileged. The documents seized at Mar-a-Lago on August 8, 2022 were seized from President Trump and were created during his term as president. Accordingly, the documents are presumptively privileged until proven otherwise. Nixon, 48 U.S. at 782. Only on evaluation by a neutral reviewer, a special master can secure the sanctity of these privileged materials. As a general matter, the likelihood that the government seized privileged material suggests the need for a careful review process. For example, while there has never been a search warrant executed at the home of a president of the United States, federal regulations acknowledge the delicate nature of reviewing all types of privileged material. Under 28 CFR Section 59.4B2, federal officers may seek to search for and seize documents from certain classes of professionals, including lawyers, only after securing the recommendation of the U.S. Attorney and the approval of a Deputy Assistant Attorney General. The message of that guideline is clear. The utmost care must be taken in the seizure of potentially privileged materials. The present matter undoubtedly involves such materials. During the Clinton presidency, this issue of privilege, specifically the presumption of privilege, was raised in response to a grand jury subpoena directed to White House counsel. See in Grand Jury Proceedings 5F, Supplement 2D 21, parentheses, DDC, and parentheses, affirmed sub nom in relation to Lindsay 148 F3D 1100, parentheses, DC Circuit 1998, and parentheses, and affirmed in part, reviewed in part, reversed in part. In Lindsay 158 F3D 1263, DC Circuit 1998, While the context differs from the present case, the court's analysis of the nature of evidence sought by the grand jury in that case applies with equal strength here. There, the U.S. District Court for the District of Columbia adhered to the Supreme Court's holding pertaining to evidence sought or seized from the President. When the President of the United States asserts a claim of executive privilege, the District Court has a duty to treat the subpoenaed material as presumptively privileged. Furthermore, if at the time the document or materials were created, they reflect presidential decision making and deliberations, they are presumptively privileged. The presumptive privilege for executive communications embodies a strong presumption and not merely a lip service reference. With the conclusion that the materials seized movement are all presumptively privileged, it is unreasonable to allow the prosecutorial team to review them without meaningful safeguards. Short of returning the seized items to movement, only a neutral review by a special master can protect the great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties, because such confidentiality is necessary to protect the effectiveness of the executive decision-making process. A DOJ filter team will not protect President Trump's rights. The government has advised counsel for President Trump that it utilizing lawyers within DOJ's NSD as a filter team. In certain instances, a filter protocol can serve as an important role where the Department of Justice seizes documents that are likely to be privileged. As the Justice Manual notes, a filter team, also called a privilege team or taint team, can be used for the limited review of arguably privileged material to ascertain whether the material is covered by the warrant and to protect the disclosure of privileged communications. U.S. Department of Justice, Justice Manual, Section 9-13, 420 at Section E. However, rather than relying on the present filter protocol, this court should appoint a special master for a variety of reasons. The implications of this filter protocol was procedurally deficient. The 11th Circuit has written, ex parte communications generally are disfavored because they conflict with a fundamental precept of our system of justice. A fair hearing requires a reasonable opportunity to know the claims of the opposing party and to meet them. In re Colony Square Co. 819 F2D 272, 276 and 12, parentheses, 11th Circuit, 1987, and parentheses, quoting, in re Paradigm Corp. 803 F2D 604, 612, 11th Circuit, 1986, and parentheses. The Fourth Circuit specifically noted the problem of setting filter protocols ex parte in reversing a district court decision denying a restraining order on the review of seized material. Among other issues, the Baltimore law firm court reversed because the magistrate judge had approved a filter protocol without conducting appropriate adversarial proceedings, which would have allowed the defense to advocate for proper safeguards. In such contested proceedings, the judge could have been fully informed of relevant background on the defendant, as well as the nature of the seized materials. Without the affidavit, the defense does not know what disclosure